September the 11th for them was a bad day. For us, it was a change of attitude.
The Military Commissions Act of 2006 is one of the most important pieces of legislation in the war on terror.
Habeas corpus, it is the last line of defense against arbitrary executive power.
The framers created a system where we did not have to rely on the good graces or good mood of the president.
Military Commissions Act.
It would perpetuate the indefinite detention of hundreds of individuals against whom the government has brought no charges and present no evidence without any recourse to justice whatsoever.
It does violence to the Constitution.
What the Congress did and what the president signed today essentially revokes over 200 years of American principles and values.
Does this mean that under this law, ultimately the only thing keeping you, I, or the viewer out of Gitmo is the sanity and honesty of the President of the United States?
It does. The Congress just gave the president despotic powers, and you could hear the yawn across the country as people turned to, Dancing with the Stars. I mean, it's otherworldly.
The bill I signed today helps secure this country.
This can go on indefinitely, and it's a self-proclaimed emergency. It's a self-proclaimed emergency.
The point here is you've heard it repeatedly from administration officials that we cannot predict how long it will go.
On October 17, 2006, President Bush signed into law the Military Commissions Act of 2006. By doing so, our representatives in Washington have committed the most shocking and openly malevolent act of giving the President of the United States true dictatorial ruling powers, and by stripping Americans of their constitutionally guaranteed right of habeas corpus. All that is necessary for someone to go to prison without any recourse to justice whatsoever is for the President of the United States to declare that person an enemy combatant. The President can label that person as either a legal enemy combatant or an illegal enemy combatant, assigning titles to Americans that presuppose their guilt and, by default, deny those people their basic right to habeas corpus. Adopted in 1787, the U.S. Constitution specifically states that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. So what is habeas corpus? Habeas corpus is actually Latin for "you have the body." Also known as the Great Writ, habeas corpus is a petition filed with the court by a person who objects to his own or another person's detention or imprisonment. But it's more than that. In family law, habeas corpus allows children who've been wrongly removed from a parent or a guardian to be returned to that parent or guardian. If you go to jail for any reason, habeas corpus is your get-out-of-jail-free card. It prevents jurors from being imprisoned for returning a verdict that the presiding judge may disagree with. And up until October 2006, it prevented the President of the United States from being able to secretly lock up anyone and throw away the key on his sole authority. Vested with the power to remove any citizen's right of habeas corpus, the President of the United States arguably has more power now than the King of England did at the time of our revolution in 1776.
I disagree with your assertion of unchecked power.
If this were a dictatorship, it'd be a heck of a lot easier. Just so long as I'm the dictator.
Well, when the president does it, that means that it is not illegal.
No one, no president, should ever be given the power to call someone an enemy combatant, make a phone call, and have that person locked up until further notice. So what gave the president the notion that he could do this in the first place? On the authority of one man, Attorney General Alberto Gonzales, the President of the United States, twists words and redefines them to his own executive benefit. Everyone remembers how President Bill Clinton attempted to redefine the word sex in order to hide his extramarital affair with Monica Lewinsky.
While my answers were legally accurate, I did not volunteer information.
President George W. Bush, on the other hand, would take the redefining of words to a whole new level. Included in the Military Commissions Act of 2006 is the government's new definition of torture.
We were using techniques like isolation, sleep deprivation, inducing hypothermia, using military working dogs. We used strobe lights and loud music for sensory overload. These things are all violations of Geneva Conventions for enemy prisoners of war.
So is waterboarding constitutional?
I don't know what's involved in the technique. If waterboarding is torture, torture is not constitutional.
If it's torture, that's a massive hedge.
As I've said before, the United States does not torture. It's against our laws and it's against our values.
It's been reported that with Khalid Sheikh Mohammed, he was what they call waterboarded.
I'm not going to talk about techniques that we use on people.
It's against our laws and it's against our values.
All of the government's documents, all of the White House documents, go to this issue of redefining torture in a way that we don't define it in the United States or in the world. And that definition says torture only occurs when someone's at the risk of immediate full organ failure or death.
Our defining moment came in 1787 when we defined ourselves in a constitutional document that committed us to the rule of law. And what would happen here if we embraced torture at the President's invitation would be to redefine ourselves. And we will become something that we have long fought against.
The Military Commissions Act gives the President absolute power to decide who is an enemy of our country, to imprison those people indefinitely without charging them with a crime, and the ability to define what is and what is not torture and abuse. It also retroactively protects the President from prosecution for having issued orders to illegally torture prisoners in his own possession. How can we expect our leaders in Washington to obey the U.S. Constitution if they don't even know the U.S. Constitution? In April of 2007, Representative Jane Harman introduced one of the most terrifying bills ever to make its way onto the House floor. The Violent Radicalization and Homegrown Terrorism Prevention Act of 2007 amends the Homeland Security Act of 2002 and seeks to add provisions pertaining to the prevention of homegrown terrorism. The bill's focal point is centered on terrorism by individuals born, raised, or based and operating primarily in the United States. H.R. 1955 specifically targets the civilian population of the United States and makes having certain thoughts a crime.
What do we want? Truth! No! What do we want? No!
This bill makes it a crime for the people of the United States to have certain thoughts floating around in their head that may be contrary to the conventional wisdom of the current administration. Are you a terrorist? You just might be. As defined in the bill, homegrown terrorism is a term meaning the use, planned use, or threatened use of force or violence by a group or individual. I think we can all agree that preventing violence is a good thing, but the red flag being waved in front of our faces actually comes from the use of the word force. According to the American Heritage Dictionary, the word force is defined as the capacity to do work or cause physical change, intellectual power or vigor, especially as conveyed in writing or speech, a capacity for affecting, influencing, or persuading the mind or behavior. Here's where you really begin to understand what the bill is attempting to regulate. Let's read the bill's intended uses and substitute the word force with the actual definitions. Homegrown terrorism is a term meaning the use, planned use, or threatened use of intellectual power or vigor, especially as conveyed in writing or speech. Homegrown terrorism is a term meaning the use, planned use, or threatened use of persuading the mind or behavior of another person. According to the bill, you might be a terrorist if you use or plan to use your powers of persuasion to change someone else's mind, either through writing or through speech. Can anyone say 1984? This bill makes anyone into a terrorist for simply aspiring to affect political, religious, or social change. Anyone attempting to think, teach, or promote concepts that challenge conventional thinking or popular wisdom would be labeled and dealt with as criminals. My question for our legislators is who gets to decide what's a thought crime? Will the definition of thought crimes change from administration to administration? Will the people of this country be sentenced to death or merely imprisoned for questioning the conduct of their leaders in Washington? If signed into law, this piece of legislation will single-handedly strip Americans of their most essential birthright that we have, the freedom of conscious thought. The very foundation upon which our First Amendment is grounded is being uprooted at the core. H.R. 1955 sets the stage for the outlawing of protest of any kind in the United States and seeks to criminalize the very conception of thought itself. Any piece of legislation that seeks to invade and regulate the thoughts of the people of the United States needs to be booted out the front door of the Capitol building along with the person who introduced it. If you agree that your brain belongs to you, please join us in contacting the House of Representatives and voicing your opinion.